Good evening. This is Rahul Reddy, live from REDDY NEUMANN PC from Houston. Along with me is my business partner, REDDY NEUMANN. We are here to present every Tuesday the immigration live news that we bring in. We bring in all the business immigration updates that went on in the past 1 week, and also what people should do if they come across with any immigration issues. Emily?
So yeah, we'll be taking your questions live as usual, and today we wanted to talk about the long process of waiting for the green card and things that you should be aware of to maintain your status during that time. We had an announcement regarding the current DHS secretary resigning, and so we'll talk about what we might expect to happen as a result of that. And talk a little bit about the H-1B cap that was just reached. We had the announcement last week that that is finished for the regular cap, how that works with the master's cap, and what if you didn't file this year, or what happens if you weren't selected, what other options do you have? So I think those are some of the main topics we'll be discussing today.
This endless journey to green card, Emily, as we know that it's a backlog for certain country nationals, is for the employment-based green card is forever. We don't know whether they're going to reach the oasis, but it looks like a mirage to me. Everything looks to be a mirage to me. Now, in these circumstances where the green card is way, way far, and now there is a 25% of the denial ratings in the non-immigrant visas, particularly in the H1Bs, what are some of the things that they can do to not fall into the 25%, and some tips, some things that they can do so that they can maintain the legal status and work in United States as long as they can?
Yeah, specifically for H-1B, where we started seeing higher rates of denial, even on extensions of people who've been here for years, all of a sudden. I think the number one thing you can do is file your extension early. Don't wait until you're close to your I-94 expiring, because if you file your extension, then your I-94 expires, and then you get a denial, the options you have are quite limited compared to if you file early and get a denial before your I-94 expires. You have the option to refile.
I want to pause here, Emily. There are a couple of different situations. Let's say, for example, the person is working in a consulting mode where there is an employer, there is a vendor, and there is an end client. If the SOW or the end client letter is not issued, it's only issued by 6 months, how can they file early in that situation?
Well, that's a good question. I would be looking at past practices of that SOW being extended. If you've been on that same project for the last 3 years and have 6 different SOWs extended every time, and have a letter from the end client that confirms that it's an ongoing project, and that explaining about how often the SOWs are renewed and that it's likely to be renewed, I think that shows at least that there's a past history of it constantly being renewed, so that it should be renewed going forward.
Do you recommend premier processing, Emily?
I do normally, especially for extensions, because you want to get the result before your I-94 expires.
Now, you said that if the I-94 has not expired, and let's say in the circumstances where they get the H-1B extension denied, what are the options that they have in those situations?
Where the I-94 is not expired?
Not expired.
Well, you may have the option to transfer to another employer if you get a better job offer that might have a stronger chance of approval. And you have the option of refiling your extension. Maybe they can make some changes to the job description, or change the SOC code, change the wage level to increase the chances of success on the second time
So these
around.
options probably they're not available if the I-94 expires.
Yeah, if the I-94 expires, your option is usually to exit the U.S., and if you're going to file another petition with a new employer, or even the same employer, file requesting consular processing, get the visa stamped when it's approved, and then come back. So it's not to say it's the end of the road if you do get a denial after your I-94 expires, but there's a lot of extra hassle factor if you do
That's
get
one
into that
step you
situation.
said is to file as early as possible, get the result before the I-94 expires, and do the premium processing. Any other steps that you think?
Yeah, I think it's important to, at least for the attorney handling the case, to be aware of the trends that are going on and make adjustments to the filing based on the most recent trends, because things do change rather quickly. Even though we have no change in regulations, no change in the law, it feels like every week we're getting a new version of requests for evidence, new issues being raised that were not raised before. So you can't rely on what you did 3 years ago to get your extension approved. You've got to look at how is USCIS looking at this today. Is this really the best occupation code that I'm selecting today? Even though it worked 3 years ago, no guarantees it'll work again. So are you truly selecting the one that's the strongest for your case? Is the wage level appropriate? Is your job description detailed enough? So many specialty occupation RFEs happen because the job description is just vague. It talks about more about the purpose of the job or the beneficiary's qualifications and why they're the best one for the job without ever saying what the job actually is. So I think those things will help give you a better chance of approval when you're filing your extension.
I also recommend that, if you get a chance, when we are looking into the statistics of the H1B data hub and also on other, general practice of noticing is that if you're working for a consulting company, your chances of denials are higher compared to when you're working with a direct employer, because there is an employer-employee relationship. There's a whole 9 yards of problem here, and if you're working for a consulting company as compared to when you're working for a direct company. So if I were the H1B person, if I have a job and if I get a job with an end client, I would choose to go with an end client, even if the salary is lower. That's me, Emily, under the circumstances. If you sometimes when people are crossing the I-94 limit, if you have an option of H4 applying before the I-94, you may want to consider that option also if you have the eligibility. Because if H1 extension or H1 transfer gets denied, you can rely on the H4 if that option is available for you. Those are some of any other things, Emily, to maintain the status now, because I go to I go to my cousins, I meet, all the cousins' kids in the Indian society. They are here perpetually on the H1B. Their kids are going to school. Their kids are becoming 21 and they're born in India, and then they're still on H1Bs. So any other tips for these people to maintain?
Yeah, a lot of people ask about the option of kind of filing a backup transfer, I would say.
You mean to say one H1B extension, one transfer?
Yeah. And you can do that. A lot of times the question comes up kind of when it's too late to be useful. If your I-94 is already expired, a backup transfer is not super helpful because you need the extension to be approved to bridge you from your I-94 expiration to the date the transfer was filed. But if your your current petition hasn't expired yet, you could consider filing an extension with your current employer and filing a transfer to a different employer. That being said, they need to be different job offers. What we see a lot of times is, well, I'm working, for a consulting company and they're filing my extension, and now the vendor is going to file my transfer to do the exact same job. And I think that conflicts with each other because both companies are now claiming that they have the employer-employee relationship with you that's needed to get the approval. And it's clear only one can have the proper employer-employee relationship, so which one is it? What are you going to say in the end client letter? Is the end client going to say so-and-so's the employer and then turn around the next day and issue a different letter that says someone else is the employer? And I think that is problematic. But if they're completely separate job opportunities, that is an option as well.
Emily, let's move on to another topic. With the resignation of the DHS secretary right now, probably, in my experience of 25 or 26, 25 years in the immigration, this DHS secretary was the toughest and not so good for the business, not so good for the immigration secretary, is resigned right now. Do we expect some good news coming from the Trump administration?
No, I think it's only going to get worse from this point. I think the reason she's resigning or been asked to resign is because she wasn't tough enough. Was trying to explain why they couldn't take certain actions because of the way the law is. And so now they want to get someone else in there that doesn't maybe care as much about that.
Are you telling that more tough actions are going to be there in the immigration, more enforcement, more restrictions, more denials are expected to come, is what we are expecting with this administration. The DHS secretary, the toughest that we have ever seen, was being let go or resigned because more tougher enforcement need to become according to the Trump administration. So
yeah, if you look at the short list of names, it's all people from CBP, ICE, people that have more of an enforcement background for her replacements, and then that this is possible to lead to the USCIS director resignation. And looking at replacements there, certainly it's not going to get any more.
I see some people in the list shortlisted were also from the FAIR organization, which is completely, according to Immigration Law Association and other people like us, I mean, they're completely anti-immigrants and probably supremacist people associated with that organization. So nothing good is expected to come with this secretary being gone right now. That's our expectation. Emily, moving on to the next topic on the H1B filings. Now we just stopped, the H1B quota. Is it over or is it still there for a master's degree? I mean, it's the Department of Homeland Security, when they released the press release, they said, bachelor's degree is over. We will get back to you on the master's quota. What do you think on that?
Yeah, I think it's pretty clear that both are technically over, but they can't actually make the announcement on the master's cap until they run the lottery on the bachelor's cap and see if they have enough master's cap petitions left over to run the second lottery.
Does it make any difference, Emily, when you're saying that if we have filed the application on April 1st as compared to April 5th, or it's the same?
No, there's no difference. Everything filed between the 1st and the 5th will be included in the lottery.
What about the application filed on 8th?
No, those will not be included.
Those will not, okay, sounds good. So for those people, whether the employer did not file a H1B, they just got a job, or maybe they didn't have a job and they are on a F1 visa or a different H4 or different visas. What are the options available for them right now? Because the next H1B start date is October 1st of 2020, which is approximately 18 months. What are the other options that they can think about?
Not a ton of great ones, but one to consider is a cap-exempt H-1B employer.
So what's that?
So if your employer that is going to be sponsoring for you for the H-1B is a university or is a company that is nonprofit and affiliated with a university or does certain nonprofit type research organization, they may be exempt from the cap, meaning that they can file their petitions all year, any time of year. So you don't have to wait until October 2020 in order to start your H-1B. So that would be one place, is to start looking for employment with a cap exempt employer.
Mostly we see that with the universities filing the H-1Bs if you can get a job from them.
Yep. Another option would potentially be an L1 if your current company in the U.S. has an office outside the U.S. that they can send you to for a year. That position that you work outside the U.S. qualifies as either specialized knowledge or manager or executive. After 1 year there, they could potentially bring you back into the U.S. On an L visa. Potential option for a J1 maybe. Depending on your industry, and it's a short-term option. The maximum time you can get it is 18 months. It's typically for an intern or trainee type position where it's more on-the-job training, kind of similar to OPT, but that at least may buy you enough time to get in the H-1B lottery next year.
Is the day one CPT an option where they can be allowed to work, join a university and get a work permit and work? Is that an option that you want?
Yeah, it's I would say it's an easy option to take, but not the best career choice for you, and I definitely don't recommend those.
I think so. The day one CPTs definitely are illegal. That's my opinion. Out of the about 9,000 institutions, only 10 institutions are giving, and these things have spread around in the community. I mean, when I go around, is that okay? These are all giving J1 CPTs, and all the people are rushing towards that. But I do suspect very much that these universities might be operating illegally. Emily, have you had any of these? I mean, other than University of Farmington, do you know any of the other university people who got deported recently?
I believe Campbellsville has had.
Yes.
That's one of the names we hear all the time that are doing these day one CPTs. I know of people that were denied entry when they were returning to the U.S. to go to school there, and yeah.
Yeah, so be careful if you are opting. We advise you guys not to opt for day one CPT. That may end that may close your doors forever into the United States. You can always go back to your home country and come back, make an attempt again. When you are outside the country, you're still eligible to file under the master's quota. There's no requirement that you must be an F1 to file under the master's quota if you do have a master's degree in the United States. The other option may be if you are married and you are eligible for H4, you might want to consider H4 EAD option in an alternative H1B.
There are a couple of other options depending on your country of citizenship. Canada and Mexico have the option of the TN. And that's even if you were born in another country, if you obtain Canadian citizenship, then you're eligible for the TN. Citizens of Australia may be eligible for the E3.
And if you're not Indian or Chinese national, you may directly go for the green card option, completely avoiding the H1B. If you're not born in any of these two countries, India or China, you may. 18 months is a time for you to get a H1B. And believe me, it will take shorter time for most of the people to get an employment authorization through green card when we file before the 18 months. So you may want to consider that option if you're not born in India or China. Emily, we have noticed as a law practitioners, we do come across a lot of people who have been getting arrested and who are sometimes have been charged with the criminal charges. When they have been arrested, I'm not speaking of the traffic tickets where you're driving at 50 miles and you're driving at 65 miles, you get the traffic tickets. I'm not speaking of those people. I mean, for various reasons, people are being arrested for, let's say, for example, shoplifting, DWI, and all these things that they get arrested for. What is the step if they are an immigrant? What should they do?
Yeah, I think number one, get a criminal lawyer. Number two, talk with an immigration lawyer because.
So you want to have both lawyers,
yes.
Just don't go with one lawyer.
Exactly, because criminal lawyers may not be aware of the specific rules for immigrants and how, depending on how the case is resolved, can actually determine whether you are going to qualify for a green card in the future or whether you become inadmissible or how it's going to impact your citizenship application. And so it's really important that the two attorneys work together or the criminal lawyer is very familiar with the requirements for immigration when it comes to plea agreements and taking these deferred adjudication type things or probation. And one thing to be aware of is even if you ultimately get the charge dismissed and your record expunged, that doesn't mean anything for immigration purposes. For criminal law, yes, expungement means it never existed, but for immigration, it doesn't matter. So you need to keep documentation of that, even if it's expunged, and you still have to answer those questions correctly on all future applications. And one thing to be aware of specifically with DWI type things is when you go outside the country and apply for a new visa stamp, for example, you're going to be referred to a medical panel. They want to make sure that you're not an alcoholic, and that is going to be a requirement, I believe, for 5 years from the date of the from the DWI. So definitely there's a lot of impact on immigration due to even just a minor criminal issue. So be sure to work with both an immigration attorney and a criminal lawyer on that.
The common mistakes that I do see in these situations is that they get arrested and the case is dismissed. That's what they think the case is dismissed. There are two ways that the cases can be dismissed. The case can be dismissed because the prosecution thinks that there is no merit in the case. The case can be dismissed because you go to the trial and then you get dismissed. The case can be dismissed because you paid the penalty for it. Now, that's where the third one is where we get very confused, because a lot of times, let's say for example, you went to DWI and now you paid $500 and you did some community service for 8 or 9 hours and the case is dismissed. That doesn't mean the case is dismissed. According to the immigration law, you are being convicted of that crime, even though the case is dismissed. So be careful on those things. It's better to speak with the immigration law. It's not dismissed. It's dismissed as for dismissed is not on the merits. It's because you paid the money, compensation to the government, or you served the community service. That is a conviction for the immigration law. So you have to, and everywhere you go, when you apply for the H-1B, when you go for the adjustment of status, you have to mention this to your immigration lawyer. I would want you to also keep the documents with you at all times. When you're traveling outside the country and you're coming into the country, sometimes the CBP gets confused. Let's say you got arrested for DWI. They don't sometimes have all the records. They only know that you've been arrested. And then when you don't have all the records, they may put you into a secondary thing, and it might take a long time for them to determine that it was a DWI. So you may want to keep all the documents together when you're entering into the country. Even if it's in any other crime, you may want to. One other thing that we advise you is that even though marijuana is legal in some states, for the purpose of the immigration, it is not legal. There is a judgment that came out recently that immigration has denied the citizenship for people who worked in marijuana industry, and even though they were working in a legal marijuana industry according to that particular state. For the immigration purposes, nothing taking the marijuana, even investing in the marijuana may also contribute to your to denials of the visas, or probably denials of the citizenship. So you may want to consult with an immigration lawyer before you do anything. Just because one particular state or some states are saying it's legal does not mean anything for the immigration. So you don't do that. Don't do marijuana. Don't sell. Don't buy. Don't invest. Even if it is a stock that you are investing online, don't do that. Now let's go back to questions and answers, Emily.
All right. So we have a question from Citi about filing an H1 extension that's pending right now and getting ready to file an I-140 in premium processing that should be approved soon. Will USCIS consider that approved I-140 and extend the H1B beyond the 6-year limit? Well, it kind of depends. So the technical rule is you have to be eligible for the extension at the time of filing. So if you didn't have the I-140 approved at the time of filing, USCIS could just approve you for whatever time period you have left and then require another extension later to get the 3 years based on the I-140 approval. That's one possibility. Another possibility is if your employer actually requested a 3-year extension, knowing that they might get the I-140 approved in time, USCIS could send a request for evidence asking for proof of how you qualify for that longer extension, and at that point you could try submitting the I-140 approval and see if they'll be able to give the extension. But the technical rule is you have to qualify for it on the day the H1 was filed, so they could always say no, but it can't hurt to try.
Annie has this question for you, Emily. I mean, I don't have the answer, exact date, so I would want you to answer this. How long is it taking for the biometrics for the people who filed in premium processing? For the H4, H1B filed in, and how long it's taking?
Yeah, so I actually updated that on my blog, immigrationgirl.com. There's a post on there about biometrics specifically, and so if I remember correctly, the first one we filed where the H4 was on the new form and they issued the receipt dated March 25th. We just received our first biometrics notice yesterday. And the notice is for appointments starting April 15th to April 19th. So it seems to be the period is a little longer than the 17 days USCIS kind of gave us as an average processing time for biometrics start to finish. But we are seeing them come in now. Yesterday was the first day we actually started getting them.
That's good, Emily. Another question that's coming out in YouTube is how to deal, this is from Gurunath, how to deal with the 221G on the H1B stamping. Is the 221Gs increased nowadays? Let me answer the second one. Yes, the 221Gs have increased significantly in the past 1 year. They have gone very significant improvement. How to deal with 221G? This is a $1 million question. They normally do the inquiry with the end client or whether there is a job. That's the normal way. And they don't, the consulates don't release any information. They blindly say, it's the security issue. We are not going to disclose anything to you. And even if you go with a congressman, that's all they say. I don't think so. It's a security issue all the time. They're just making an inquiry into your company. They're going to make inquiry to your end client. If the job exists or not, they're doing some background checking on that. Typically, the time is taking in some of the consulates is approximately between 2 weeks to about 2 months. Now, that's the typical timing, though. We have seen cases taking longer time than that one, but 2 weeks to 2 months is the time that is taking for them to adjudicate. Then in cases where it's taking longer time than 2 months, and in some cases even if it's 2 months also, we are seeing that the job is lost because the employer doesn't want to wait that long for you when you're outside the country, and eventually you will be withdrawing the application. And this administration will go to the Congress and say, hey, we didn't deny the H-1B, the person withdrew the application. They take it so long to frustrate you so that you lose the job. Since you lost the job, people like us will recommend to withdraw the H-1B application in the consulate, and then they go to the Congress and say, the guy withdrew the application, we didn't deny it. So be careful, the administration wants to trap you by you going to the consulate. So before taking that step of going outside, you be well prepared. We tell people, when they are going outside the country, make sure you make provisions to sell your home, sell all your belongings if you before you go out to go for stamping. That's the provisions that you have to make when you go out.
A question from Facebook is, what can we expect from the lottery? When is there going to be an announcement? When will we find out results? So based on last year as an example, we got the announcement the Thursday after stating that the lottery had been done, and they'll start sending out receipt notices. And then probably within a week, we started receiving receipt notices in the mail. So I expect it to be similar. When they do announce that the lottery has been done, I expect they'll probably have another announcement that the master's cap has also been filled and that lottery has also been done. Again, this year's a little new because of the way they're doing the lottery reversed, so we can't rely on our past experience, but that's kind of what we're anticipating. So receipt notices should start arriving in mid-April. If you filed in premium processing, email notifications usually start coming in mid-April, and those can continue all the way to May 20th, which is the actual start date for premium processing. So between mid-April and mid-May is typically when all of the receipt notices are mailed out and people find out whether they were selected or not.
Emily, are you going to update this on Immigration Girl?
Absolutely.
And Emily is going to update on the lottery results every day on when they are coming, how much percentage have already been issued. So please log on to immigrationgirl.com, and she updates every day since the time the lottery system will start when we start receiving the receipt notices. Shiva has this question from YouTube that he was being given a ticket for driving without a license. Then he went to the court, showed them the license, they dismissed the ticket. Will it have any impact on the H-1B? Now, this ticket has been dismissed because there is you have the driving license. So no, that will not have any impact whatsoever on your immigration, neither H-1B nor anything else. But I want the other people to be very careful that there are some states, if you don't have the license and you drove and you get a ticket, some states consider that as a major crime. One state of that is Ohio. I can't name all the states, but one state I can name is Ohio. That maybe you might have to report that to the immigration lawyer to see what actions he wants to take when he's filing for the H-1B or any other non-immigrant visas and immigrant visas.
I had a question about an update on the H4 EAD. So I just double checked that we still don't have any movement at the OMB. The proposed rule is still pending there for their review. And at the same time, as far as the litigation, one of the briefs from the Immigration Voice was due yesterday. I did not check whether they filed it. I'm sure they did, but I have not looked at that. But the next brief is not due until April 29th, which means we're not going to really see any action until after April 29th now. So that's just the first round of briefs. And then we'll have to see if the judge orders more briefing, or if they want to have a hearing, or if the parties make different motions. But expect it to be a couple of months from the time that last brief is submitted until a judge actually makes a decision. So nothing's going to happen anytime soon on the litigation side. On the regulation side, we're just waiting for the OMB to finish their review before we can actually see what the proposed regulation actually looks like.
Sagar Reddy has this question. He got his EB-1A approved with a priority date of April 2018. When do we expect his priority to be current to file the adjustment of status? As you may already know, Sagar, that the priority date right now is in 2017. I'm assuming you are born in India. And even though the gap seems to be like a 1 year gap or 1 year, 2 months gap from the time the priority date is to yours, the priority dates don't move exactly that way. They move zigzag. Sometimes they go forward, sometimes they go backward. Now, we will try to come up with explanation of why these priority dates don't move properly and why they keep on moving up and down, up and down. We'll come up with a separate video for that one day. Now, here is what I would suggest to you, Sagar, is that there are 40,000 EB-1 green cards available. So when the 40,000 gets filled out, any country that's taking more than 7%, they cut off. And so India is the biggest backlog in the EB-1 category right now. Now, previous to 2017, previous to 2018, 2017 and 2017 and all those years, the EB-1 didn't used to get filled out. So when it doesn't get filled out of the 40,000, 7% is 2,800. So Indian nationals used to get more than 2,800. But when I look into the priority dates right now, it's backlog for all nationals for a particular time, but Indian nationals more higher. And Chinese nationals are also in the same category. So Indian nationals are only allowed to get 2,800 if everything is getting filled out. So I'm not expecting a fast movement based on this in the EB-1 category for Indian nationals. It may take 3 to 4 years for you to become current. It may take 1 year also. We can't tell it exactly, but based on the trend, it may take 3 to 4 years.
Pragnya from Facebook has a question. Pending H-1B extension, and now there's a location change that requires an amendment. Can you file an amendment of the pending extension? So I would want to know whether your I-94 has expired or not. If the I-94 has not expired, I would probably withdraw the pending extension and file a new amendment plus extension to allow you to work at the new location. In the past, maybe 2 or 3 years ago, we were able to amend a pending petition and were successful many times. Starting about 18 months to 2 years ago, they started denying, saying that the initial job no longer existed, it was speculative, and they would not allow you to file an amendment of the pending petition. They'd end up sending a request for evidence and then denying both. So hopefully the I-94 is available to allow you to just withdraw the pending extension and refile an amendment plus extension.
Uday from YouTube has this question that his H-1B has expired, he's in Canada. Can he work in Canada and get paid in USA? The first, let me answer you, if you're in Canada, you have the work permit in Canada, I'm assuming, then you can work for a US employer. Absolutely you can. The law is the place where you sit down in the chair. Let's say you sit down in this chair and you're working. It doesn't matter where you log in. The government at this point of time does not recognize cyberspace as a space. They only recognize the space as a space, the space where you sit down. So if you're in Canada, you have the work permit in Canada, you can work. If you're in India, your work permit in India, you can work. Now, where you log in, to which employer you work in, does not matter. You can work. Now, coming to the point of the employer paying the taxes of the US, that's not allowed because he can just give you the check and then you are supposed to pay the Canadian taxes because you're working in Canada and that income you're deriving in Canada, so you are subject to the Canadian taxes, you're not subject to US taxes. You can raise an invoice and employer can pay absolutely no problem. Employer can, by suo motu, can pay the money to you because you worked and he can pay, but you're subject to Canadian taxation, not US taxation.
Gautami has a question about a H-1B change of status filed in premium processing in this year's CAP while also filing an H4 EAD extension in premium processing with their spouse's H1 extension, both going on at the same time. What happens if her H-1B change of status gets approved and then right after that the H4 and H4 EAD get approved? What happens? Is the H-1B canceled? The H-1B is not canceled. The petition remains approved, but the status becomes an issue. USCIS looks at what we call the last action rule, and the last action at this point is the H4 approval. So even though you got the H1 approved, your status could be considered to be back in H4 because that approval came last. Now you can rectify that on October 1st when your H-1B is getting ready to take effect by simply traveling outside the US using automatic revalidation. If you go to Canada or Mexico for less than 30 days, you don't have to go for stamping. You go out and come back in showing your H-4 visa stamp that's in your passport, even an expired H-4 visa stamp, but your H-1B approval notice that has an I-94 on it. You should be allowed back in H-1B status. That cures that problem.
Salai Khan from YouTube has this question, Emily, that I may want you to pay attention to, is that can he file the H-1B and H-4 in premium processing? Are the H-4s getting approved along with the H-1B since the biometrics has come? I mean, this is where, since the biometrics have come right now, that's the reason why he has a question from YouTube. Do you have any test cases? Because it started only in March 20.
Yeah, I mean, I'll tell you that the case I talked about earlier where we got the biometrics notice yesterday, I already have the H-1B approval notice.
So in other words, H-4 is not approved?
Right.
So
we'll have to wait. Probably by the end of April, we'll know what the real processing time is, because in that case,
so in other
the
words,
biometrics
if
appointment.
the H-1B and H-4 has been filed together, the H-1B got approved, but the H-4 is not approved because they're waiting for the biometrics.
Right.
Now the question is that as soon as the biometrics is over, would they approve the case immediately, or would they put on the normal processing, which might take, especially in Vermont Service Center, approximately, I don't know, maybe 12 months or so. So I think so that we want you to wait a little bit right now to get more results to get it. What I am thinking at this point of time is to file H-1B and H-4 together, and don't file in premium processing. Once the biometrics are done, convert that into premium processing, then you may get both of them approved. But that's just my guess right now. You can be my guinea pig, or you can wait and we will inform you next week. I would want you, Emily, because to inform this one too.
Yeah, I have that blog post on immigrationgirl.com. If you look for H4 or I-539 biometrics, it's at the very top. I'll give updates of when we received the biometrics notice, when the appointment is, and I'll definitely be updating when we actually get the H4 and EAD approved. And I've asked others to share their experience in the comments as well, so you'll be able to see what other people are experiencing and whether they've tried it, whether they waited and then upgraded later, and whether that worked. You know, it's kind of all brand new right now. So all we can do is guess on how it's going to work out. USCIS did say that they will process it fast after the biometrics are done because they understand it's done in premium processing for a reason. We just don't know how fast is to them.
And the articles that we write, Emily writes on Immigration Girl, it's not like the rest of the thing, guys. She monitors it, she spends a lot of time on it, she updates it based on the information, she updates it based on the feedback, and she monitors it. So it's not that she just writes an article on Immigration Girl and then lets it go. No, she updates it based on the information. For example, as she said, on the biometrics, she updates it very regularly. Please log on, subscribe to immigrationgirl.com. Not just biometrics, even if you are waiting for a quota and you want to get the current news. Because I have been through the immigration process. I know, am I getting my H-1B? Am I getting a H-1B? You need update every day. And Emily does give the quota updates every day. In the same articles, she updates it every day, especially for the quota.
Ravi Prasad has a question on Facebook. If the H-1B petition is approved without an I-94, is there any time period or grace period for the person to travel outside the U.S.? So I'm assuming the situation is it's approved without an I-94 because the extension was denied. The extension request or the change of status request was denied due to maintenance of status or lack of maintenance of status. In that situation, if the I-94 has already expired or they've determined that you are not maintaining status and you get the approval without the I-94, there is no grace period, 0 days. Now, does that mean you have to drop everything and leave within 24 hours? Not necessarily. It has to be reasonable. Obviously, it takes time for you to receive the approval notice, know that there's no I-94 on it, get your plane ticket and all of that. But definitely don't hang around for a month thinking that you have a grace period, because there is no grace period at all.
I have a couple of quick questions I want to go in from YouTube. H-1B has been approved. H-4 extension is still pending. Can the spouse go to the home country and get the H-4 stamping without any problem? Yes, the H-4 can go to, because your H-1B is already approved, that person, the spouse, can use the H-1B approval to get the H-4 approval. You don't need a H-4 approval to go for the H-4 stamping. So you can do that. The next question from YouTube is, my spouse's H-4 EAD is expiring in 1 year. I'm moving to a different company. Can she still work? Do I need to file another H-4 EAD? She can continue working on the H-4 EAD. Absolutely no problem. Even if you move to a different company, she can continue working for the H-4 EAD.
Sachin has a question. You might be a good one to answer this. If someone has an approved advanced parole, and they also have an H-1B, but they filed an extension and it's pending, and they need to travel. If they travel, can they use the advanced parole and skip the stamping? Do they need to wait for the H-1 to be approved?
I don't see any reason why they have to wait for the H-1B approval. I don't see a reason for these people to go and get the stamping on H-1B. I mean, advanced parole is a very good option to come in. The chances for you to get into trouble is absolutely very rarely. I mean, I've not seen any advanced parole people getting in trouble. Now, I don't understand why you need the H-1B extension at all. Because if you get the H-1B extension, you're going to go for stamping, and there is about 20% 221Gs. And if the H-1B stamping is denied, you can't use the advanced parole to come back into the country. Once the visa has been denied, everything is canceled, so you can't come back into the country. So absolutely, you don't have to use that H-1B. Just go with the advanced parole and come back. As long as your I-140 is approved and you're good in that thing, I don't see a reason why you need the H-1B extension.
Nizar has a question on Facebook. The H1 extension was filed 3.5 months ago, still no update. Can you file a transfer now? It all depends on whether your I-94 has expired or not. If your I-94 has expired and you're relying on the pending extension, then you file a transfer. If that extension gets withdrawn or denied, that is the bridge between your I-94 expiration and your transfer filing, and the bridge collapses, meaning your transfer is likely to be approved without an I-94, putting you out of status. So not a great time to file a transfer, but if your I-94 has not expired yet, yes, you can file a transfer.
Is it safe to travel on OPT when and get an F1 stamping when a change of status has been done from H4 to F1? No, because we are noticing a lot of F1 stampings getting denied right now, because when you're trying to enter back into the country in F1, you need to prove that your intention is only to temporarily stay in the United States. Since you maintained the H4 before, that has become a major problem, because your spouse is in the country working, and your intention, when you express your intention that you want to come back to your home country after you complete the F1, becomes very tough to prove. I don't recommend. Emily, also I want to address another issue on these F1 visas, people filing from H4 to F1 visas. Significant number of people are getting an RFE this time, and the RFE is questioning what their intention in the country, to show their intention is only temporary in the United States. How do we answer those things?
Yeah, that can be hard to do if your spouse is here on H1 and maybe has an I-140 approved.
That is definitely a serious matter for you. I would recommend to consult a lawyer. Maybe withdraw the F1B. That might be another solution you might want to consider. You can study on H4, there's no doubt you can study on H4. But F1, you have to prove that your intention is temporary. In the past 1 week, we do conduct daily conference calls, half an hour. In the past 1 week, I received 5 calls in there that they have received an RFE on this one.
Good to know. Sourav, speaking of kind of these change of status that are taking forever, Sourav has a question on Facebook. The change of status from F2 to H4 has been pending for about 6 months. At the time they filed, the processing time was only 2 months, and now all of a sudden it's 15 months. Is the spouse legally in the U.S., and can they remain until the decision comes? So assuming that the spouse was maintaining F2 status at the time of filing the H4 change of status, and we don't know if this was based on an H1B cap case that was approved. I'm guessing the main applicant went from F1 to H1 and the spouse went from F2 to H4. So assuming that all of the status is maintained at the time of filing up till the H1B takes effect, then yes, the pending change of status keeps you in what's called a period of authorized stay. It's not the same thing as being in status, because you're no longer in F2 status because your spouse is no longer in F1 status, but you're not yet in H4 status because it hasn't been approved yet. You're in between, and that's what's called a period of authorized stay, but it does allow you to stay as long as it's pending, and then once it's approved, it puts you back in status.
Naveen has this question for you, namely, is that his perm is approved, he's about to file the I-140, should he do premium processing? He has 2 years left on the H1B. Are there any advantages and disadvantages in filing a premium processing? Let me tell you, file in premium processing, period. Here is the reason why you should file in premium processing. Let me tell you the disadvantage people will tell, and that is the biggest lie that we know about, is that the premium processing gets more RFEs. No truth in it. No truth in it. That's number one I want to dispel. Why do you need the I-140 approval earlier? Here's the reason. If you have an I-140 approval, and if it's 180 days has passed since your I-140 has been approved, that will be stamped like a tattoo on your face. And you may need that for the H4 EAD approval. You may need that if you want to move from that company to another company. You may need that for a lot of different purposes. I would want you to get the I-140 approval as early as possible, because the 180 days H4 EAD, and who knows, maybe your job might have some issues. You may lose a job after a while. So within the time period before the I-140 is approved, or within 180 days after your I-140 is approved. So it's for all reasons you need to get the I-140 approval earlier. No reason to wait for the I-140 approval.
Somyadeep has a question on Facebook. Can you have extra income from rent from an investment property while being in H-1B status? Probably, as long as it's really passive income. You maybe have one rental house and it's rented out and you receive the checks and that's all you're doing, should not be an issue. Now, say that compared to you have 10 rental houses and every day you're going around looking at a different rental house and you're having to do maintenance on it and you're acting as the property manager and you're spending a lot of time and effort, that might be getting a little closer to unauthorized employment because you're not authorized to be acting as a property manager versus a passive investor. So the typical, I'm renting out a room in my house, or I have a downstairs apartment or something, or I bought a rental house and I'm renting that out, just one, that's probably okay.
Atul has this question on YouTube. Can you work on H4 EAD when the H1B is on 240 days? I want you to come to our conference call, daily conference call, because what's the reason why the H1B is on 240 days and the I-94 has expired, and you have a H4 valid? So that's a doubt that I have. So these kind of things, maybe we need more interaction. And of course, we're coming with a new system where we'll have a phone live probably by end of this month, or probably early May. We'll have a phone interaction where we'll have these questions asked on the phone, because we need some interaction in this one. Why is your H4 valid when the H1 has expired and it's been more than 240 days? That's number one. Number two, what is your spouse doing for 240 days? Why can't he file a premium processing? It doesn't make sense to me for that. So we would recommend to come to the conference calls, check our conference call details at rnlawgroup.com. Yes, sir.
Shravya has a question on Facebook. Is it safe to travel before October 1st with the H-1B approval notice and valid OPT and the valid F1 visa stamp that has not yet expired? I can't say it's 100% safe, no. Is it technically possible to do that? Yes. Based on the Hernandez memo, it says that once your H-1B change of status is approved, but it hasn't taken effect yet, you may be able to travel, re-enter an F1, and then the last action becomes the H-1B change of status, which actually occurs on October 1st. The difficulty is, number one, are you going to be allowed in? Because when you're coming in on an F1, you have to prove that your intention is to study and that you have non-immigrant intent, meaning you're going to leave. Yet you've got this H-1B approval over here that says, hi, I'm planning on working, don't mind me. So you have to be really careful about whether you're going to be allowed in. And then the other issue that comes up with this play on the last action rule, yes, there is a memo that says the last action will be the H-1B taking effect, but that memo is over 10 years old. At that time, there were not the same level of government databases compared to now. And so I think it's very possible that you might end up with an I-94 problem when you do that, because when you come into the US, you're going to be assigned a different I-94 number, but your H-1B approval is going to have an old I-94 number on it. That can cause you trouble when you're getting your driver's license renewed, because they use that SAVE system where the state driver's license agency contacts the immigration service to verify things, and they can get all confused and it can take months to resolve. So I would really question whether it's worth it to travel during that short period of time.
I want to add one more trouble to the troubles that you have listed, Emily. Don't forget that the intention of the person to come back into F1 need to be proved. And F1 intention should be only to temporarily stay in the United States. Since you already got the H1B approval, your intent is changed right now. You may not be eligible to come back on F1. even though we have not seen those rejections before at the time of entry, based on the past 1 week where all these H4 people got the change of status RFE on it, show the intent for the F1, I do doubt that you might even be denied entry into this country, because this administration want to implement everything so strictly, and we do have a doubt that this might play at any time, and they may deny your entry if you're coming back on F1 when you already have a H1B approved.
Suresh has a question from Facebook. If H1B and I-140 are approved, is it still possible that you'll get a 221G when you go for stamping? Absolutely. I-140 approval means nothing. H-1B approval just means your petition was approved. It doesn't mean you're eligible for the visa. And a visa can still be denied. You can still be stuck in administrative processing just even if you have those both approved.
Biju has this question, Emily. I think so I can answer it, but I need backup from this. He has a EB1 I-140 approved. He has not filed the 485 application. Can he change the employer? Yes, you can change the employer, but for you to get the EB1 approval, again, I'm assuming that the EB1 is based on EB1C, which is multinational executive. If it is EB1 extraordinary ability, I don't see a problem in changing the I-140. I don't see a problem. He can continue moving to a different job under limited circumstances and continue with the I-140. May be able to continue. When it is an EB1B, which is EB1B category, which is the outstanding researcher, definitely if you move to a different company, you will have to file the I-140 again. And it depends on whether or not you are eligible under the EB1B. And EB1C, you can't get another EB1C I-140 approval by moving to another company. So if you're planning to downgrade it to EB2, I don't see any problem in you moving. But if you're planning to stay on EB1 category with a different employer, you may have a big problem in either EB1A, EB1B, EB1C. Either of these, all these three categories, you will have a tough time in getting an I-140 approval. I would recommend that you contact a lawyer if you want to maintain the EB1 category. Now, if you want to downgrade, we don't see a problem. Emily, can you correct me on this?
Yeah, I agree.
You agree? Okay.
Maybe time for one last question. We'll take one from Nikhil. What is an advanced parole? Can you please explain? So advanced parole is something that you get when you file your adjustment of status. That's the last step in the green card process. So when you file your 485, it makes you eligible to also file an application for advanced parole, which basically means you're asking for advance permission to exit the U.S. and come back in without abandoning your pending adjustment of status. So once you have an advanced parole approved, if you want to travel, you can go out and come back in using the advanced parole and no longer need to get a visa stamp or use a visa stamp for your non-immigrant status. So that's kind of the benefit of advanced parole. Once you get it, you no longer have to go for visa stamping anymore and can use the advanced parole to travel again, and then use the EAD based on the 485 to work.
Thank you guys for coming to our YouTube and Facebook Live. The next YouTube and Facebook Live will be next Tuesday at 5 p.m. Please put comments on how we did. We do read the comments, and we try to adjust based on the comments and your recommendations and your suggestions. Please subscribe to YouTube and like us in the Facebook. Thank you, Emily.